Hello, my friends. It is Saturday evening, December the 29th. I'm going to do a little invites here. I hope you all are out doing something fun on Saturday night instead of sitting at home and maybe, I don't know, maybe you did enough partying over the Christmas and you're thinking about partying on Monday night, Monday night, and you don't really want to go out tonight, so that's okay. So I just wanted to say hello and see what everybody's doing. Yeah, got a couple things to talk about. Okay, it is, I'm sitting here all red-faced because I'm in my red room. This is my room that has red walls, as you can see. I have a red sofa. The tinge of the light reflected on everything makes my face look all red, so red happens to be my favorite color. So this is me in red. First of all, I just finished a huge brief that I've been sweating. I probably put 40 hours into it. It's involves some issues that have never really been addressed before, and the case is like many of my cases. It's under seal and gagged and everything else, so I can't tell you the I'm looking at the shares here. You know what? I may be able to share that to, nope, can't share that to the group. I'm so sorry. Yeah, if somebody can share that to Arkansas, it would be great. But anyway, I just finished this big brief, and you know, when I have to do a huge legal brief, it really requires me to go into this kind of hyper-focused, like blurry-eyed, trance-like state, because especially with a lot of the things that I do, there are issues that have not really been addressed before, and there's just only like cases on the side or side issues. So I have to take like bits and pieces of law and then think through them logically, and it's really funny when I do that when I start pulling cases on a certain point, you actually find a lot of contradictions in what the law says about some what you thought were very simple issues. So it was a real challenge. It ended up being 32 pages, and I cut it down from about 40 pages, was able to take some stuff out of it, but very, very, very intense. And so when I do that, when I finally finish something, I print it off. I'm going to have my other attorney in the office do a final read through. I sent it to my co-counsel to have him do a read through on the legal arguments. I'll have it read for typographical errors and technical consistencies on Monday morning, and then I have to file it on Monday the 31st. That's my deadline. Always on deadlines. You know, the courts and the law, when you're an attorney, they just control your life. So this was on a deadline. That's for Monday. I also have a few other deadlines in front of me. So what I did to celebrate is I took my granddaughter out, and honestly, I had myself a little vodka and cranberry juice so I could let my brain relax. And so I thought I'd just come on and say hello. So we had Christmas. I think the live event went very well. I hope everybody got to enjoy at least listening to somebody that was on live Christmas Day. Even if you were with family, it was kind of fun to watch different people talk about stuff. Most people had gratitude in their heart and were very thankful of Dr. Carlos for putting it together, and very thankful to the other advocates that had worked so hard during the year. And that really was important and warming to me, because I know there's been just some weird stuff. I posted a post this morning that I hope you got a chance to see. And I took a picture of some of the books that over my last 20 years that I have read, just kind of about human nature and psychology and the way people think. And I've read probably 50 books, probably more, hundreds of books. And I did a little photo of some of those and shared it. And one of the things that I posted was I really felt like 2018 was not a very good year for relationships. It's I looked up the Chinese, just out of curiosity. I looked up the Chinese year, what it was, and it's the year of the dog, which can be interpreted as the wild dog, which gets in the way of progress. So, it's been it's been a year. I think we've had a lot of challenges. I've seen a lot of people with personal challenges in relationships. I've seen a lot of challenges that we've had in advocacy in relationships. I know people have shared with me certain situations where, they tried to reach out or do something for somebody, and it ended up really harming them, the person who tried to help, all in the quest for kindness. And it's it's unfortunate. Part of that comes because sometimes in our effort to want to do good, we don't screen it out ourselves enough. We don't use some caution in setting our boundaries and with what we deal with. So I just urge everybody in the area of advocacy and working in child welfare that you do use your good common sense and you use your own instincts for caution. And those are natural instincts. That's not anything bad. And caution, a healthy amount of caution, helps us set boundaries, helps us be inquisitive, helps us sort of know what our limitations are in the effort. So, please just keep that in mind. And there's so much we want to do, and there's so much that, we just think we should be able to do, and sometimes we're not able to. So just be wise about that. Also, just in the nature of relationships, a lot of people in this world are hurt, and a lot of people that we've touched through the child welfare advocacy are people who've been hurt. Whether or not they've contributed to it or not, it is an issue, but at the end of the day, there are folks that have some pain. And, I've been in a place where I've had pain. I understand that, but, we've got to, sometimes we have to draw them back in. And we have to do that as well with a bit of wisdom and patience and understanding boundaries. And sometimes people just need a place to voice themselves when their anxiety is high. I've talked to a few people. I see some people post some things on Facebook when their anxiety is like going through the roof, and I try to be patient about that and just ultimately sometimes people just need to be talked off that ledge, so to speak, and encouraged to just kind of sit back and give things a little bit of time. I know a lot of people have in advocacy had some really aggressive things that they were trying to do this fall related to the election, and some things didn't happen with the election that we wanted, and there were some people who became so frustrated, and people who throw up their hands and say, I quit, I'm out of here, I can't do this, blah blah blah. I'm just going to say we need every voice. Ultimately, at the end of the day, we need every single voice we can get. So no matter how frustrated you get, it's okay to take a couple days off. It's okay, like me, to go, have a little libations or, and do something for fun to get your mind off of it. But you need to come back, and you need to be stronger, and you need to have direction, and you need to be willing to learn. We need to be educated. We need to be articulate. We need to be determined. We need to be decisive. And the numbers are growing. In Family Forward Project, we continue to have growing numbers every day. I don't know where people are getting all the information from. I hope you're sharing it with other people and reaching out and sharing it. I'm getting more people that are coming into the group who are outside professionals who've been involved with CPS. with foster parents, with children, people who are now adults who've been through foster care. And it's those voices and it's those collective kind of voices that are going to make us stronger and more credible. You know, we also want to reach out to those who have the ability and authority to help make change. And it becomes very frustrated when you think, I spoke to this state rep or this state senator or this governor's assistant and they didn't do anything, right? I mean, I get it. I know. I mean, I've shared a lot of voices, but you know what? Don't stop. Don't stop. The voice has to be like thunder, and it has to be persistent and ongoing. So you've got to speak. All right, I'm going to take a few minutes here because I have posted this a few times, and I've got other people who are posting files on Family Forward Project, and so this keeps getting buried. And I want you going into 2019, I want you to be very aware of what it is. About 2 or 3 years ago, I put together what I call the Family Integrity Act. And I have some people who in their states have provided it to legislators, and I want you to think about legislators that you can pull this off and send it to. It's going to take a minute to read it because I tried to be as comprehensive as possible, but I'm going to read it out loud to you so you know exactly what's in it. It's called the Family Integrity Act. This is an act to support families through the Child in Need of Care proceedings, which emphasizes placement with extended family, involve parents in the needs of the removed child, strengthens judicial oversight, and further protects the child through an assignment of rights and promotes integrity of all parties. Whereas this state holds as self-evidence the constitutionally protected right of privacy to parent one's child and protect one's family without government interference except where there is substantial risk of health, welfare, or safety of a child is imminent. Whereas the importance of family heritage, and the right for children to grow up living with and knowing their biological family and extended family is the foundation of this state. Whereas the removal of a child from their family and extended family should occur only as a last resort to protect the child and for no other reason. Whereas ignoring the fundamental and constitutional right to parent has long-term, lasting, harmful effects on children, family, and the community. Whereas placement in foster care causes known emotional trauma to children that is irreversible, and such trauma must be avoided by use of family placement when circumstances present that prevent a child from living safely at home. Therefore, the obligation be it enacted by the legislature of the state of blank. Okay, so you put your state in there. Obligations of and authority of the courts. And this is broken down into separate sections, and this is the first section. The court shall never lose the right to remove the child from placement selected by the state agency, notwithstanding any state law that gives the state agency exclusive right to place a child in any setting at their sole discretion. I'm going to read through these and I'm going to come back to some of them. No court shall accept a stipulation from a parent that compromises their constitutional right to parent without fully going through the detailed stipulation, ascertaining the truth of the facts by affirmation, and informing the parent of the impact of the stipulation, including the obligation of continuing financial support due to the state and potential termination of parental rights on the record. There shall be no secret ex parte communication with the court by agency attorneys, court-appointed special advocates, guardian ad litems, attorney ad litems, or otherwise prior to or during an investigation or prosecution, including any filing with the court. Okay, a couple things here. One of them is that DCS, once they have your kid, they can do whatever they want with them, and the court doesn't have any say over it, and that needs to be changed. The court needs to be able to have some authority over that. Stipulations are really dangerous tools that are used against parents. They have attorneys who say, well, why don't you just stipulate to just like the lowest level of neglect, and then we'll work on getting your kids back. And parents do this without understanding what the full force and effect of a stipulation would be. The ex parte communication is horrid, and it is the beast. It is the beast monstrosity, the devouring devil of family court. I hate ex parte. The next section is called the obligations of state agency and those appointed by the state. The state must make appropriate notifications to parents so as to not violate the constitutional rights of any parent subject to investigation or prosecution. Each parent involved in an agency investigation or court proceeding shall be provided a copy of every court document, agency record, evaluation, drug screen, report, medical record, and any other documents filed, used, or related to their case, regardless of the source of the document, within 10 days of the creation of the document. Each parent shall be provided a copy of all interviews, whether taken of children, witnesses, or professionals, and whether documented by note-taking, audio, or video recording, regardless of the source conducting the interview, including CASA workers and guardian ad litems within 10 days of the interview. No state agency shall indicate or otherwise ascertain the status of a parent as an abuser of a child without a full evidentiary hearing specific to the matter of placing the parent on public abuse registry and obtaining a ruling from the court that the case warrants listing on such registry. No parent shall be placed on any publicly accessible list for indicated child abuser prior to a full evidentiary hearing and all appeal options have been exhausted. Court-appointed advocates and guardian ad litem shall not interview children without the express permission of the parent and must make a video or audio recording of those interviews which shall be subject to discovery. The removal from the home must include an articulable, immediate threat of serious harm. The facts which shall be verified and the source of all information shall be disclosed if the same is to be used against the parent without independent investigation and confirmation. In the event the state moves for removal of a child, the state will abide by parental rights, which provides the highest level of emotional stability for a child facing removal from their parents and primary home. Foster care can only be used as a last resort. In the event of removal from parents, the state shall not automatically enroll the child in Medicaid, but must obtain insurance coverage information from the parent. Where medical coverage provides for adequate medical care, then the child shall remain solely on the private insurance plan and continue services with the primary care and other physicians that have a treatment history with the child for the purpose of continuity of care and to provide the court with a comprehensive medical history on the child before and after removal. Foster placement in an emergency situation may occur but shall end within 12 hours upon notice by parent of a named family or friend placement under the parental rights, Section V2. Should the state oppose such placement, the state must file for an emergency hearing and provide a sworn affidavit that outlines the reasons for such opposition and demonstrate that it poses an articulable and serious threat of harm to the child so that the court can determine if foster care shall continue or if parents' desire for family or friend placement will be upheld. The hearing must take place within 10 calendar days of removal, or the state must comply with the parent's selection for placement. 10 days is too long, actually. That should be like 2 days. 10 days is a long time in the life of a child. No attorney shall accept a court appointment for representation unless they are trained in defending parents and have secured liability insurance for negligence in their representation. Any attorney who accepts an appointment is verifying his competence in that area of law, and said counsel do not have immunity. No immunity shall be provided to court-appointed special advocates or guardian ad litems, as they are expected to maintain integrity, competence, and knowledge to serve in their capacity without bias or prejudice. They shall also be expected to secure liability insurance for their respective negligence. They shall also be subject to liability under civil rights litigation and intentional torts. Any state agency employee who is found by the court to have knowingly, willfully, or recklessly misrepresented any fact to the court shall be immediately removed from working on the case, and the state shall refer the complaint to the district attorney's office for review and prosecution as appropriate. Any parent may raise this issue with the court by motion indicating where and how the false information was provided or used, and supported by affidavit of the parents describing how said information was false. All agencies, guardian ad litems, court-appointed special advocates, and attorneys shall preserve all communications, including electronic. There shall be no attorney-client privilege for the communication of court-appointed special advocates regarding their investigation, and all records shall be provided to the parents within 5 days of written request. There shall be no attorney-client privilege for the guardian ad litem regarding the investigation and prosecution in any court action. Their records and communication shall be provided to the parents within 5 days of written request. Requirements that are imposed upon a parent shall be written in written form, indicating all necessary information for the parent to achieve the required task within a date certain. No agency or appointee by the state shall require or demand anything of a parent that is not fully documented and approved by the court. Services shall not be provided by the same contractor who shall have competing interest in the outcome of an investigation or litigation regarding the constitutional right of a parent. That is, no foster care agency who profits from the placement of children in foster care shall serve as an agency providing family preservation services, as to do so is a direct conflict of interest. Finally, children's rights. To have the court preserve the child's ability to remain with their parent when allegations made fail to show an articulable and serious threat of harm exists. I'm sorry, I'm going to start that over. These are children's rights. It's written a little bit different. So these are a list of children's rights. It is the children's right to have the court preserve the child's ability to remain with their parent when allegations made fail to show an articulable and serious threat of harm. Understanding that removal from the parents is known to cause substantial psychological harm to a child. It is a child's right to have the court preserve the child's ability to remain with biological family, extended family, and family friends when remaining at home with their parent is not possible. It is a child's right to have the court assure that foster care is only being used as a last resort and not as a primary placement. It is the child's right to be protected from coercion and threat used as a tactic to elicit information from the child. It is a child's right to be protected from anyone attempting to make a child feel unwanted or unloved by a parent. Children shall not be interviewed without the permission of their parent unless the agency has clear, articulable evidence of a serious threat of harm to the child. In the event, the agency shall seek a court order documenting the facts by affidavit to justify this intervention, and the interview shall be conducted in the presence of an adult who is not associated with the department, and that should say, and recorded. Oh, next section, sorry, jumped ahead of myself. Every interview shall be recorded by audio or video recording and maintained by the department. If a video is not available, then the department must allow the parent's attorney or In the case the parent is not represented, a witness of the parent's choosing to be available during the audio recorded interview. Interviews must be provided to the parents and their legal counsel or to the parent if acting in their own defense within 10 days. Interviews shall be conducted by a person licensed and trained to conduct forensic interviews of the children. The interviewer is required. Yep, I see that, Robin. It's already up, but I will. Interviews shall be conducted by a person licensed and trained to conduct forensic interviews of the children. The interviewer is required to inform the child being interviewed that he or she is not required to talk to the state agency worker or law enforcement. In other words, Miranda rights basically for children. Should a case require removal of the child and the parent of the child makes no recommendation for placement, or the parent is deceased, unable or unavailable to make a recommendation, then a biological family member who can demonstrate that they were an active participant in the child's life will be given primary consideration for placement via petition for custody. Barring the state's ability to prove to the court that such placement with a biological family member filing the petition poses an articulable and serious threat of harm, the state will be required to make the biological family placement. How am I doing? Yeah. I missed the beginning. Yeah. This is for all of America. Yes, Brittany. You can go back and watch the beginning when we're done. All right, we're still on children's rights. Any child removed from a home shall have the maximum amount of time possible of continued contact with their parent during the term of removal. The court shall ensure that the parent's time is maximized. Failure to do so shall be considered a final order and is the basis for immediate review by a higher court. All appellant reviews in cases involving the removal of a child from a parent shall be expedited, and the court shall clear their document to accommodate the hearing schedule at the pleasure of the parents and their attorney. In other words, the parents have priority on the calendar instead of the agency. The agency in the court is required to assess any parent for disabilities which would qualify for protection under the Americans with Disabilities Act. Upon such assessment, the parent shall be provided reasonable accommodations for parenting, which shall include the active participation of family members to assist in parental responsibilities. Okay, that section was all children's rights, okay? And again, there's reasons for every one of these things that I put in here. After over 25 years, all these things have come up, and I see you guys ask these questions and parents come up with these things over and over and over, and I'm not done yet. Okay, here's the last section is parents' rights, okay? The last section. Each parent is entitled to be informed that they have a Fourth Amendment right against unlawful search and seizure before any government agency worker or law enforcement can enter their home, and that they have an absolute right to refuse entry and to refuse to be interviewed. Each waiver shall be in writing, signed by the parent, and a copy provided to the parent. No parent shall be threatened or coerced into allowing entry into their home or interview of themselves or their child for failing or refusing to waive those rights, right? I mean, criminals have that much right, so you should too. Parents shall have the right to video and audio record all interviews, meetings, contact, and hearings, whether agency or court hearings, as a matter of record, and they shall be advised of their right to do so prior to the commencement of the proceedings. The unavailability of a recording mechanism shall constitute grounds for continuance upon the request of their parents or their counsel. A lot of this has to do with giving people rights and then telling them they have those rights, okay? Criminals have this all the time, and I'm going to talk about that in a second. Each parent at risk of losing their right to the care and custody of their child through intervention of a state agency has the absolute right to select a caretaker for the child, which shall be approved by the court, absent a showing that such placement poses an articulable and serious threat of harm to the child. This placement shall not revoke the parent's superior right to parent. Each parent shall be informed in the event of foster care placement if the foster parent intends to seek adoption. Parents should have the right to know whether or not the foster parents are trying to get their kid, okay? Critical information, you know? Children are not puppies, okay? Just because you kept my puppy for the weekend doesn't mean you can have him, right? Same with kids. No parent shall be taxed with fees or cost of court-appointed attorneys and guardian ad litems in an amount that exceeds the state-approved payment of fees for indigent parents. Big deal, too, because, once in a while, just because, if you don't qualify for indigency, but you can't afford an attorney, then you're really stuck in the middle, right? Parents who are middle class, they have an okay job, but, they can't break the bank and, to dish out $40,000 for an attorney, they should be able to have some rights for litigation support. Okay, hang on here. I'm not done. No parent shall be required to pay child support to the state when a child is placed in its custody. Any parent who directs their funds to the hiring and retention of counsel instead of making payments of support to any third party shall not be punished with contempt, nor shall the failure to make payments be a basis for termination of parental rights, whether to the state or to a third party. In other words, and here's the deal. They have this thing, if you don't visit your child, your rights can be terminated. However, it says that if you were not able to visit your child, then that doesn't count. Well, it's the same thing with paying support. If you have to make a decision as to whether or not I'm going to pay child support or hire an attorney to be able to save my parental rights, what are you going to do, right? And they trap you on that. No parent shall have their right to parent interfered with without a showing beyond a reasonable doubt upon expert testimony that the child has been subjected to substantial harm. Okay, this, of course, we will never get a state to pass this, but this is exactly the standard of proof that is required under ICWA. The Indian Child Welfare Act requires proof, a showing beyond a reasonable doubt, which is the criminal standard for evidence, and it has to be based on expert testimony, and it has to say that the child has been subjected to substantial harm. That is the ICWA standard, and not a single state for us non-Indian folk, not a single state has that standard for terminating a life sentence of losing your right to parent your child. So long as the parent has parental rights, the parent is entitled to notice and to attend every medical appointment of the child. The parents are also entitled to the child's records within 10 days of treatment and assessment. A parent is also entitled to all mental health and counseling notes and records of the child within 10 days of the treatment or assessment. A parent maintains the right to oppose treatment and may seek an intervention by the court for alternative treatment, including medication and therapies. The court will allow the parent to seek alternative opinion for care and treatment of the child for good cause on a preponderance of evidence standard. Parents will have access to the child and all records for this purpose. The state will pay for the alternative review unless the court finds that the parent is abusing process. Now, some of these things, of course, they'll find a way to twist everything around, and, they'll try to say that the parent can't create good cause to get different treatment, or they'll say the parent has to hire a doctor before they can even take it to court or something, but at least it's a step in the right direction, especially where they want to stick these kids in foster care and then put them on meds. Finally, All parents have the right to rebuttal expert testimony, which shall be paid up to the state allowed level for criminal felonies. Parents shall not be restricted to seeking experts within a limited geographic area. Okay, sorry about that. I had a little belch there. But that means that you can have an expert. And right now, I mean, people don't even know this, but if you have a court-appointed attorney, there are expert fees that are available, the same as if you were in criminal court. So I don't know what your individual case is, but it can be an expert on medical, it can be psychological. I mean, there's different kind of experts that you can have in court, and sometimes you need to think about that. Okay. All right, folks. Well, it is Saturday evening, and I hope you all are just relaxing and getting ready for the big New Year's. 2019 is going to be our year of awareness, right? Awareness. Where we go one, we go all. And Yellow Vest and People Speak. And, you know, lots of crazy things happen in Washington, D.C., and we just can't let that get in our way. I don't know what all is going on there, but we're going to keep moving because we are the heart of America. We are the people, and it's our money. They're spending our money, our tax dollars, the money that comes from our paychecks. And the money that comes from our paychecks is what's going to create this mess. And so we're going to speak because it's our money. Don't forget that. Those people work for us. Your state reps, they work for us. And it's uncomfortable sometimes when we complain. And you need to do it civilly, and you need to articulate yourself, and you need to be educated. And, we're not Antifa, so we're not going to, we don't need to do anything violent, but we're going to be persistent and educated and speaking clearly, succinctly, persistently with a voice of thunder. All right, now I've seen a few of you ask that I tag you on that thing I just read out loud, and so I'm going to do that. I don't know if I can put it in these comments, but at least I'll do a brand new post right now and make sure that file is there for you to read through yourself. If you find any typos or think my wording isn't just right, I won't be embarrassed or threatened or hurt or disgusted if you tell me you think I need to change something, because everything is open for modification at this point. Okay, all right. Okay, I see a lot of people have joined. I hope you pass it around, and let's get some people to watch this so that we can get this. I'm going to put the title on this as the Family Integrity Act. You need to pass it around, and let's get a lot of views on this. Okay, our videos are getting lots of views. We need to keep passing them around, and another reason why we need to be educated and articulate, because more and more people want to know. More shows coming out, more news stories, more things happening. We're here for the whole show. Okay, we're going to stay till the curtain closes, right? Or as they say in the opera, until the fat lady sings. Okay, all right. Love y'all. All right, y'all be good. I'll talk to you later. Bye bye.